Good afternoon. Welcome to WARF Entrepreneurons. My name is Laura Heisler. I'm Director of Programming for the Wisconsin Alumni Research Foundation, or WARF, and we are delighted to welcome you to today's session. I want to just give you a couple of housekeeping notes for how things go here at Entrepreneurons if you haven't been before. This session is going to be a little different from our normal interactions. We're going to be taking your questions throughout as we go because we're doing a top 10 countdown, and so as we go through our top 10 challenges, you'll have the opportunity to ask questions of our panelists. We do ask, because we record these sessions, we do ask that you wait for one of the mic runners to reach you if you have a question. That way we'll capture your question on the video. We keep all of the videos of all of Entrepreneurons on the WARF website, which you can find here, so you can always go back and take a look if there's something you want to follow up on. I know that also this session we are listing the contact information for our panelists at the end if you want to follow up with them in more detail as well. So I think this will be a really informative and interactive and dynamic session. I also want to make you aware of the final session of this semester on April 10th. I have a feeling this topic will come up today, the question about conflicts of interest for how to start a company on campus. And so you might want to come to that if you are thinking about starting a company. This panel, as we were going through our planning, agreed that that would be an important thing to bring forward this semester. So mark your calendars, and if you got an email for today's session, you'll get an email for this one as well. Also, just a couple of housekeeping notes for what happens after the session. So we're going to go until probably about 5:30, and then we're going to conclude with an informal networking reception, and you're invited and encouraged to join. There'll be beverages and some food right behind you in the atrium right behind you, so do stick around. Please do, though, grab a name tag if you haven't already. That's sort of your ticket to the reception. That way we know that you're part of what we're doing here, and you're welcome to participate. So without any further ado, I'm going to go ahead and introduce the moderator for today's session, and then when he comes up, the panel will come up and we'll get things started. So I'm delighted to welcome my colleague from WARF, Justin Anderson, who's going to be moderating the session. Justin is a double badger, having gotten degrees in both chemical and biological engineering and biochemistry here at UW-Madison. And if that weren't enough, Justin is now pursuing his JD at the law school here. He's also a registered patent agent with more than 10 years experience in managing intellectual property for WARF across a variety of disciplines, including chemistry and engineering. He also worked as a process engineer and spent a year working at a clean tech startup where he drafted patent applications and managed an active IP portfolio that included numerous patents, trademarks, and trade secrets. So I'm delighted to welcome my colleague Justin Anderson and the panel. Please come on up.
Thank you very much, Laura, and thank you all for attending this afternoon's Entrepreneurons. I have the distinct pleasure of moderating this panel of distinguished folks from the ecosystem here within UW, as well as from outside the university. And as Laura said, we're going to try to keep this pretty interactive, so as questions do bubble up, please feel free to raise your hand and we'll get a microphone to you so that we can answer your question as best we can. We've also got, obviously, some questions prepared, so hopefully that can help spur some interest and some spirited exchange here. So I'm going to have the panelists go ahead and introduce themselves, and then we'll dive right in. So, Mike? I guess I'll start. Can you hear me? Mm-hmm. Great. My name is Mike Williams. I'm the director of the Business and Entrepreneurship Clinic here at the UW. I also teach entrepreneurship in the business school. In my career, I've had quite a few titles. I had to write them down, so I'm going to put my glasses back on just to give you a little background on me. I've been a chief financial officer, a chief operating officer, a director of financial planning and analysis, business manager, business analyst, budget analyst, and a mortgage loan accountant. From companies that were starting and very young to companies that grew into Fortune 500 companies like Nextel. I started my own consulting company after I took the company public and did that for about 5 years. And I've been on teams that have raised around $200 million in loans and when we took the company public. For the last 5.5 years, I've been here. Hi, Ann.
Hi. Sorry I'm late.
Last 5.5 years, I've been here with the clinic. Helping early stage entrepreneurs do a whole range of various business, going through business issues, from financial modeling to digital marketing, sales strategies,
and it all depends on what stage they are in. We're closing in on 200 clients, I'm really happy to say. We've helped Brewpub open, we've helped some smaller companies raise, smaller amounts of money, but still, it's that's always a tough environment, so we're proud of that. So I will send it to you, Ann.
Hi, I'm Ann Smith, and I am the director of the Law and Entrepreneurship Clinic, and I also work with a seed accelerator called MadWorks. What do I do every day? That means I, just like Mike, work with a lot of startups. Just like Mike, handle a lot of the broad breadth of the kinds of companies that anyone in this room would want to start, from a food cart to regenerative medicine startups. So it's whoever comes to the door, we do what we can to help them, and we have an advisory committee made up of lawyers from private firms like Melissa, who, when we get stuck and can't quite figure out what we think the best answer is for someone, they're there for us, and they've been an excellent, wonderful safety net, and they've helped us learn and develop and get better all the time. Before I did this, I worked in-house for insurance and biotech, and this is a lot more fun.
Thanks, Ann.
So I'll go next. Hi, I'm David Ertl, and I am a mentor in residence here at the Discovery to Product program. It's right across the street if you don't know where it's located. My background is product management and strategy for IT companies, the likes of IBM, Sage Software, and Metavante over in Milwaukee. So basically that means that I help manage products, either get to market, brand new products, or in market, large established products, figuring out what the roadmaps need to be, how to align with customer demand, managing P&Ls, those kinds of things. So I bring a lot of industry experience to bear on technologies and helping them figure out path to market. I've been here at D2P for about 3 years now. I've had the opportunity to work with at least a couple of dozen startup hopefuls here at DW, and some of them have done fairly well. So had a good track record going, and
my name is Melissa Turczyn, and I am an attorney at Michael Best. Like Justin, I'm actually a double badger, so I'm really jealous that you're going to be a triple badger, because I might have to go back to school for
Just
that.
like Troy.
I know, I was like, that's a thing? Like, I didn't know that was a thing. So I actually lead our firm's venture capital practice, which is known as Venture Best, and that is the practice internally that works with early stage, high growth technology companies. So similar to Ann, but probably later stage, I get involved when companies are just getting started, if they're at the idea phase. We work with them to get organized, to bring on founders, employees, contractors, raise money, and we're a full service, Michael Best is a full service business law firm. So to the extent that they have litigation issues or real estate needs or employment, immigration, we essentially operate as in-house counsel, just not the in-house piece. But everything that they're doing runs through my office. I get to be the quarterback for them and help them kind of grow their company, get funding for their company, hopefully help them sell at the end of the day as well.
Well, thank you all. So as you heard, we obviously have a rich and varied experience here on the panel. So I think with that, we'll dive right in. And when we were thinking about this, we were asking ourselves, really, what are kind of the common questions that we often hear at WARF and across campus and then beyond? And we were wondering really kind of where to start. And so that led us really to our first question, is that we often hear, where do I get started? Who do I talk to first? When is the right time to engage the ecosystem if I have an idea, a concept, a business model, and who do I talk to? When is it too soon? Is it too late? So with that, I'm going to turn to Ann and ask her, being at the Alumni Clinic for as long as she's been, when is the right time to get started?
Well, that's an interesting question. That is generally pretty fact-specific to the person that comes to us. But if you think it's time to get started, then it's time to get started. And the answer for you may be you're not ready yet, go and do these things and then come back. Or it may be, oh my gosh, you're really ready, you better go see Melissa because you've outgrown us already. So it is very specific and depends on what the person brings to us. I think that David has some specific issues he wanted to talk about with regard to researchers.
Sure, I'll get into that, and that's a good lead in terms of, where do you start. Pretty much depends on where you are in the process, and I think everyone who comes through the door at D2P is almost at a different starting point. But what I can say is avoid rushing out to start a company, because that's really not your first checkpoint unless you've done all the rest of the things that we're going to talk about here today. You're not ready yet to start the company, and there's a lot of good reasons for that. But in terms of research, I would say, the way grants are going, there's a lot more emphasis put on commercialization of whatever it is that you're applying for in terms of grants. And so, with that in mind, I would say really that's about the time you want to start talking with somebody about commercialization, even if you don't have an idea of where your research might go. At the same time that you're writing a grant proposal to the NSF or to the NIH, that's a good time to start thinking about, is there some future for this commercially, and what kind of thought process should I go through as I'm putting some text into my research grant. So even that early in the process, I would suggest getting involved with someone like at D2P or someone who's been through the process already to think about commercialization. I think another pretty logical checkpoint for you is at the time that you do your invention disclosures to WARF. That's also a good time to think about, what's a commercial path for this? Is this something that I might start up as a company, or is this something that WARF is going to license for me? Where's the path forward from there? So that's a good time to start thinking about it. Then after you do an invention disclosure, WARF doesn't choose everything to patent, so just because they didn't decide to pursue patenting doesn't mean that you can't pursue starting a company with your technology. So even after invention disclosure, if you've got the idea that this could have commercial legs, you should start talking with somebody about that. And then finally, kind of the best place to get serious about it is and start to look for real help outside, like real working help, is after you've kind of done the bench work, got some prototypes, maybe bench prototypes in place, and you have a working solution. So I call that proof of technology. So when your technology gets to the point where you think it actually works and it's going to solve problems, and you think you want to start a company, that's a great point to reach out. That's kind of for a research-based project, but we deal with a lot of different types of projects at D2P, and especially in my space, which is IT and software. Really, at the idea phase is a good time to come down and chat with us, pick our brains, see what we think should be your next most important things that you work on. And we do that a lot. We'll sit down for 30 minutes. We'll have you go through what your idea is, what you're thinking, and then we'll oftentimes give you a good next couple of things to go work on and then come back and talk to us.
Yeah, thank you both for that. And I think, one of the other things we wanted to highlight is that we're all pretty interconnected here, in that if you do have a question, be it about, business model, be it about invention disclosure, be it about entity selection or formation, we can get you in touch with the right people. So I think that's one of the other takeaways, is that we all kind of work together and are aware of maybe some of the people that we can put you in touch with if we don't ourselves know the right path or the right answer. Anything else, any one of you that have to add on, maybe how much time and effort, about one or two things that entrepreneurs may typically overlook as they're maybe thinking about getting started?
I would definitely say I think that people underestimate how much work it takes. Thanks for the softball. It's a lot of work to get a company started, and that first sale can be really hard, and people think that it's really easy, and they may come to us before they need a customer contract. They tell us they need a customer contract. Say to them, well, tell us about your customer. And they don't have any. They just know at some point in the future they're going to have them. And what we try to do is get them focused on the marketplace as opposed to worrying about all their legal issues. They can deal with their legal issues in the right order, but if they don't have a product anybody wants to buy, they're not really going to end up ever with any legal issues.
Great.
And I would just say too, I mean, I think don't be afraid to reach out to attorneys early. You know, coming in and having an hour meeting with me is not billable. You're not going to get a bill in the mail. And there's definitely times when I meet with people and I say, you know what, like you need to go do X, Y, and Z and then come back to us. So just because you go meet with an attorney doesn't mean that you're going to have a whole laundry list of legal needs that are going to have to be done. And we do, you know, make referrals to Ann's group and to others. So like Justin said, we're all interconnected, and we're really, I think people that are in this industry try and help everybody else. And so we're not going to do something that, you know, is going to set you back months. If it makes sense to get started, it makes sense. But if it doesn't, there's definitely meetings where I say, you know, call me in 3 months when you've checked off these boxes and we can talk.
And even people that have been through our program before, the entrepreneurs themselves, they're a great resource for somebody that's just trying to get started. So we often connect at that level as well.
All right, so shifting gears a little bit and thinking about company formation, one question that we had that came to mind was really, what is an entity and which one may be right for me or my company? So Melissa, maybe you want to give us some indication there.
Yeah, I mean, there's 3 types of entities roughly, without getting into, you know, B Corps and limited liability partnerships. There's obviously others, but for the most part, startups are going to look to be an LLC, which is a limited liability company, an S Corp, or a C Corp. And I can pretty quickly kick out S Corps, at least from my practice, because
Lawyers do, accountants don't.
Yeah, exactly. Yeah, you'll get a different answer if you ask your accountant this question. But if you're going to, you know, if the hope is to be a successful startup, kind of what we all think of as a startup company, you're going to, at some sense, probably earlier rather than later, have one of 2 things that are going to create issues for you if you set up as an S Corp. The first is that you're going to want to have entities that are going to be investors in your company, other LLCs, other S Corps, other C Corps. You cannot have that. The ownership of an S Corp is restricted to individuals and certain types of trusts for the most part. So that's going to kick you out. The second piece is, if you start going down a funding path, you're going to have some level of preferred stock. Maybe it's a Series Seed round, maybe it's a Series A round. S Corps can only have one level or one class of stock other than voting and non-voting. And so that pretty quickly is going to kick you out as well. So if you want to be a technology company, just skip S Corps. Which leaves you with an LLC or a C Corp. And this isn't going to be a tax. I'm not going to lecture for a long time on tax, but LLCs have one level of taxation. So a lot of times people say, we just want the pass-through tax treatment, which means the entity itself is not taxed. The owners are taxed. The benefit of LLCs, in addition to that, is there's a lot of flexibility that you can have. You can have various classes of units. You can have voting and non-voting units. The other thing that's unique to LLCs is something called a profits interest, and it's a way to incent employees in a way that is not there's no sort of applicable mechanism in a C Corp, and it's beneficial because it's not taxable to the employee when you're making that ownership grant. So LLCs, if you don't expect to raise any type of institutional money for the next 2 to 3 to 4 years, you're probably okay to start as an LLC. And the other caveat I'd say is it's easier to go from an LLC to a C Corp than to go in the reverse of that. So if you're not sure, a lot of times most people start as LLCs, and we can always fix it at some point in the future. The other entity is a C Corporation. That's what most technology companies are. There's 2 levels potentially of taxation. The entity will pay tax, and to the extent that it makes distributions or dividends, the shareholders will be taxed. Now, I don't know many technology companies that are making distributions to their shareholders regularly, so from a practical perspective, that probably isn't that big of a deal when people are concerned about 2 levels of tax. But most technology companies that we work with are C Corps. If you come in a meeting and say, I intend to raise some level of institutional money in the next, I'd say 12 or 18 months, that's probably going to be the way that we recommend you start as a C Corp. It's a little bit more expensive from a legal perspective to start as an LLC, and if you incur the conversion costs as well, you know, it adds on some fees. So we usually recommend a C Corp, but there are definitely situations where an LLC makes sense. So I'll stop there because that's a lot for you to digest.
Thank you for that. Anyone else on the panel have anything to add about that? I know it's great to highlight kind of thinking about your entity at the outset, and again, kind of going to funding and what type of company you're going to be. And it's nice to hear that it's not necessarily set in stone, and that it can be changed, but maybe a little bit more expensive or more difficult. So always good to have in the back of your mind. Any of the other panelists want to weigh in?
I would just reiterate something that Melissa said. As a startup, you're not likely to make much money, if any. So a lot of people come to us and say, oh, I don't want the double taxation. When really, if you don't make any money, you're not going to pay any tax at all anyway. So it's a little bit overblown.
Yeah. All right, great.
But I guess I should say that the other side of that is that if the corporation is accumulating losses, you can't pass that through to the individuals that and take the tax loss for that if it's a C corp.
That stays within the company.
So something to consider, and you need to talk to these two over here.
Yeah, I think if you're going to start a biotech company or a medical device company or something that's it's going to be years, right, of substantial losses, that may be a situation where an LLC makes sense to be able to capture those.
Great. All right. We'll move on to the third question, which we get asked quite frequently, is about agreements. An operating agreement, a partnership agreement. What types? When do I need these? What are they protecting me from? So maybe we'll turn to Anne to get us started on this. So if I come to you and ask, why do I need an operating agreement, or what's in a partnership agreement? What would you tell me?
So I would tell you that in an operating agreement or a partnership agreement, not quite the technical term for that, but that's okay, is the agreement with the people you're going into business with about how you're going to how you will work together. And it is really important. I think when you go into a business, you think things are rosy and it's wonderful, and why do I need all this? That an operating agreement is particularly detailed, and it can be tedious for people to think about all those things, but it is, in the event that your entity doesn't make it, you have a roadmap to how to dissolve it, how to let people go, how to bring people in. So it just makes a lot of sense, even though it is tedious.
Any of the other panelists have anything to add on that?
Yeah, I think so. There's two things I would say. One, your operating agreement is critical for the reasons that Anne talked about. It specifies who's going to make the management decisions, who controls the day-to-day decisions of the company. What is the split of allocations and distributions and profits and losses? Are there transfer restrictions, or can any of your coworkers, your co-founders, go out and just sell their shares to somebody without you having a say in it? The other thing I think that is just as critical, I would actually probably put it kind of 1A and 1B, is some type of an understanding of vesting among the founders. This is one of the things that we see errors in all of the time, and unfortunately it's really hard to unwind this. And what I mean is, if you are getting into business with there's three of you, all of your units or your shares should have some level of a vesting schedule, so that on day one you're not all fully vested. Because what happens if you're all fully vested on day one, and on day two one of you decides to move to Texas to start a barbecue joint? You now have somebody who owns a third of your company that's no longer providing services. And you also need to replace that person, and you have to come out of your own equity, presumably, to do it. So I think part of what goes into that initial discussion about management and things like that is, what is the vesting schedule going to be, so that if somebody decides in 6 months, I'm just not going to be here anymore, and it's a mutual parting, at least the company gets that equity back and can plan, for the future. So Anne's right, you're planning for the worst. But in that as well goes some level of a vesting schedule, because that's one of the things that we see people just don't do. We're all friends, it's going to be great, and we all know how that turns out. And
I think that point is particularly important with campus startups, because people on campus in general are more transient than the general population. Students come and go, they form a team, they think this is the greatest thing, somebody gets a great job offer, they're gone, or you're working in a PI's lab, and you're a postdoc, and you think this is going to be the way to go, and then you get a job, and you have to weigh the issues, and you leave, and then the company is left to pick up the pieces. So I think in this environment, it's even more important than anywhere else.
Yeah, and this is one of those things too where being proactive is very helpful. It can be painful and difficult at the outset to be dealing with this and to have to address it with your partners and those that are going into this business with you. But after you've established it, it gets even more painful when people are leaving and you're having these more difficult discussions when there may be actual money on the table or customers that are lined up, and that can really cause quite a disturbance. So you want to have most of that spelled out and called out in the operating agreement to the best of your ability, of course.
And I'm just going to tell the story.
Yeah, sure.
Funny, we had a client, the founders were dating at the time they founded the company, and they came to us when one of them had gotten a job and a new boyfriend, and the other was still plugging away at the company, and they wanted some help in separating. And it was complicated because one had a mom that was a lawyer and one had a brother that was a lawyer. And then we were there. So it was quite an interesting adventure in how to separate with each other. They had formed their own LLC using LegalZoom, so they really didn't know what they had agreed to, and it didn't really help them resolve this situation very well. So think before you.
Great. Well, thanks. Yes.
The vesting agreement. Can you give us kind of an example of how long the type of agreements that you do many times in these startups from universities?
Yeah, I mean, so typically a vesting schedule, a very standard vesting schedule is 4-year vesting, 4-year monthly vesting with a 1-year cliff. What that means is you don't vest anything for the first 12 months. If you're there on the 1-year anniversary, you get credit for that whole year. So a quarter of whatever it is will vest to you. And then for the next 36 months, everything remaining vests. There's a couple reasons for that. One, I think it's always better if somebody's going to have a break from the company. We usually recommend monthly vesting versus quarterly or annual because things move so fast in a startup. And if somebody's going to have a break from the company, they may want to stay until the end of the month to get their next vesting chunk, but we certainly don't want them sticking around for 6 or 7 months because they know that next, chunk of equity is coming and they just got to stick it out. When the companies are so small and you get sort of a person like that, they can really cause a cancer. And so that's why monthly vesting is much more standard. If founders have been working on this for a bit, so we see this a lot with like accelerator models, for instance. If founders have been working for 6 or 7 or 8 months and they've all sort of been pulling their same weight, I'm happy to give them credit for what they've put forth, and maybe we vest, a quarter of it up front and then they vest for 3 more years or something like that. So you can play around with 2 years, 3 years, 4 years, whatever sort of makes sense. But the point being, have something in place that's over some next foreseeable future, so that if somebody leaves for whatever reason, you don't have somebody on your cap table that owns a substantial chunk of equity who's no longer contributing value. And almost more importantly, you have whatever that returned equity is to go hire that person's replacement because you're probably going to need it. We typically bake all of that into what we call a founder's agreement, and that speaks to vesting. It usually has any type of IP assignment provisions in it. So if they're creating discoveries or things that potentially are patentable or copyrightable, it's clear that the company owns all of that. It'll have confidentiality provisions in it, and it will typically, well, I wouldn't say typically, if there's going to be a non-compete, it would be in that same document as well. And so each founder will have their own founder's agreement. It's just an agreement between the company and that specific person.
Great question. And I'm really glad you brought up a couple great things. We're going to get a little bit more into equity a bit later, and then we're also going to segue here into intellectual property. So I'm glad you mentioned that again in kind of this founder's agreement, how intellectual property will be handled. So let's shift to that. So when you do have an idea, how do you protect it? When is the right time? Who do you engage with? What types of ideas are protectable? And when we talk about protection, what exactly do we mean? So Anne, maybe you want to talk a little bit about when the right time is to consider intellectual property protection.
Well, the right time well, you should always be thinking about your intellectual property, but the right time to protect it is once it really is something. A lot of people come to us with an idea and say they want to file a patent, and you can't file a patent on an idea. You have to be able to reduce it to practice. So, and if you think about that, you have an idea, and as you get to the point where it actually is something, it changes significantly from the time you came up with the idea until the time that it really is something. And you can't be involving, I mean, in the real world, if you hired a lawyer to draft a patent for your idea and it kept changing, you'd have to keep paying that lawyer to fix it. So you want to make sure that you have something that truly is producible and then thus protectable before you start. Now, there are things like copyright, which is a form of intellectual property that you get as soon as you write the words on a page. So if you do programming, there's a common law copyright in those words, but then if you change one word, then it's a new copyright. So if you file a copyright, you have to again, it's one of those things where you have to keep up with it. So if you are thinking about copyright protection, make sure you're at a point where it is a solid piece of work that you want to file the copyright for. And then there's trademarks, and we do a lot of trademark work at the clinic. Most people have a name that they want to protect with a trademark, and your brand can be a very powerful tool for your company, so it's a very good thing to do once you know you're serious about your business. And then there's trade secrets. You can always keep your idea just secret, and people do that in a variety of ways. Coca-Cola is a prime example. No one knows the complete formula. Some people know there's people that know parts of it, but very few people know the whole thing.
Yeah, and for us at WARF, obviously we would advocate for early disclosure to WARF or to someone on campus that can get you involved in the disclosure process, because one of the things we're oftentimes thinking about, to contrast with the trade secret, is that most of the information and the discoveries that are made here on campus will ultimately get shared publicly, be it in a manuscript publication, some sort of poster presentation, an invited talk. And so what we're always trying to battle with or to address is that we're trying to get patent protection, which oftentimes requires absolute novelty. And so we want to have something on file with the patent office before that public disclosure occurs. Now in the US, we're fortunate in that we have a 1-year grace period from that first public disclosure, but it's always best to be proactive and to be thinking about patent protection or intellectual property protection before that occurs. Any of the other panelists have anything to add on the difference between maybe a discovery and an invention and when it's right to engage?
I don't know that I have that, but since my world is software and copyright, I thought I'd spend just a
Yeah, please do.
A couple of thoughts on software copyright. First of all, I see a lot of projects that come through that use packaged software or licensable software in the creation of their novel idea. You got to be kind of careful with that, because if you ever want to take that out as a product, those software packages that you used, MATLAB, etc., to create your innovation, those you'll either have to license from that and pass it through to your customer, which is very expensive, or you'll have to write a piece of custom software that does the specific functions that you're using that software. So that's not how do you protect yours, kind of how do you protect yourself and deliver a product to your customer that's free and clear of any kind of copyright infringement. And the other thought I had about software and copyright is, and this is based on experience in selling and servicing products that are copyright based, is there's not a whole lot of protection, honestly, for copyright, and it's not that hard to duplicate that. It's typically not, there used to have issues with, I would get Microsoft Office CD and I'd give it to my friend. That pirating is kind of what we think of as copyright infringement. In the business-to-business environment, that doesn't happen very often. It's actually very but what more often happens is somebody looks at what you've created and says, that looks like a great way to do it. And then it's not too hard for them to spin up a development team and recreate what you've done and not violate copyright law. So don't expect a lot of protection from copyright unless somebody truly is plagiarizing and actually lifting your code and putting it onto their CD without paying you. So guess the caveat is a couple of things. One is copyright doesn't give you a whole lot of protection. That can't easily be worked around in the industry. So have a good idea, have a strong company behind it, produce a great product and service it well, and you'll end up doing better than trying to litigate and protect yourself from copyright infringement.
Now, we joke that actually the world of patents is the sport of kings, because there's a lot of cost involved in patenting a product, and then if you need to defend yourself against infringement or you want to sue someone, litigation runs in the hundreds of thousands of dollars to either defend or charge someone with infringement. So you have to really be serious. I think that's really where WARF if you have the power of WARF behind your patent, you can scare people away. It's something you wouldn't do if it was just you as a startup trying to protect yourself.
Yes, indeed. Yeah, go ahead.
Can I piggyback on what David said? So one of the other big issues that we see with early companies is maybe their company is set up and they are paying somebody, a third party, to develop their code, and there's no agreement that goes back to the company that they own that code. And they say, well, I've been paying them, of course I own the code. And the answer is you don't, because the person that you're paying to develop the code actually owns that copyright. And if you don't have an agreement that they assign you that work product as a work made for hire, your rights are going to be very limited in what you can do with that. So we see a lot of times that is something that if startups don't get right, you can pay thousands of dollars and all of a sudden you don't own kind of the app or the software piece that you thought you did. The flip of that coin too is if you come in and say, I have a full-time job right now, me and my buddy on the weekends in the garage are going to start the software company. The other kind of gotcha here is to take a look at what's in your current employment contract, because we have seen where you are bound that everything you're developing, if it relates to the business that you're working for, is owned by that business. And it gets into, what are the specifics in the contract, but if it's not clear that if you're doing it on your own time, on your own resources, with your own laptop, using a different email, all that kind of stuff, you could be spending your nights and weekends developing something that your actual current employer has rights to own. So those are the two, pay attention when you're developing things. A lot of times when it's code, people just are assuming, I'm doing this, I'm paying a third party. You can actually create a lot of issues for yourself if you're not careful.
I think we have a question over here. Yeah.
Just a brief question about Creative Commons licenses. Does WARF get into that terrain at all when people would like to protect property but will not go as far as the kind of copyright we have right now, but would like a Creative Commons license?
I am not familiar with us at WARF ever entering into any type of Creative Commons license. So I can't comment on that, but I could get back to you on kind of how maybe we could think about doing that in the future. Anybody else have anything to add on that?
I do think the two issues that Melissa raised are a reason why you should talk to somebody when you want to launch your company, because you make those mistakes and they're serious mistakes, and a conversation with someone, a lawyer or any of us who could then refer you anywhere or help you out, would help you start off on the right foot.
Actually, we did have, I'll tell a quick story. We did have a client who, had this great relationship with these two gentlemen. They were developing the code for her. She paid them between $35,000 and $50,000, and the work was done, and she could not get them to assign over the rights that she was using. And we did an extensive agreement. They didn't like that. We tried to scale it back. They didn't like that. They actually then said, well, we've used, off-the-shelf open source stuff. We can't give you a license and ownership to that. We tried to put it into buckets, right? Like, tell us, okay, what did you actually create that is specific to the company? We need to own that. It is a huge ball of wax. There are certain legal issues that if you get wrong up front, it's pretty easy to fix. This is not one of them, because a lot of times they sort of have you over a barrel, right? You may have to pay them more because they just will not assign it to you. And if you're working with a good development firm, some type of agreement up front is really standard. And if you ask for that and that developer, goes running for the hills or says, I've never signed this, you may want to look for a different developer.
And because you said open source, I'm going to go ahead. Customers might look at that as a real red flag. That open source code. So let's say that someone's doing a medical procedure based on your software that you've sold to them, and the patient dies, and then you get sued. So what's going to happen is they're going to look for who's responsible, and if you've used a whole bunch of open source code that was the fail point in that, you have no way to go back and pass that liability along to the person who provided that code to you. That's kind of a outlier example, but open source code is a very red flag if you're intending to resell something. If you're going to use open source code in your back office to provide services to your customers, that's fine. You can service it, you can manage that. But if you're delivering code to somebody that's got open source inside of it, you lose a lot of protection and control.
That's great. So obviously, based on these comments, intellectual property is a very weighty and complex subject. So be thinking about it, though. As we're creating intellectual property here on campus, and if you are going to commercialize that, license it into your startup, be thinking about when that maybe splits off and you start creating intellectual property within the company and having the right agreements in place and to ensure that the company is retaining title to those inventions. Certainly something to think about. So we talked a little bit about the expense involved in intellectual property, but starting companies and developing products is very expensive. So let's shift a little bit to funding your startup and what type of funding may be right for you. Obviously, we talked a little bit about entity formation and how that impacts your type of funding and vice versa. So I'll turn to the panel here. Does anyone have any thoughts on types of funding? Bootstrapping, taking an angel investment, going to your friends and family. What are we commonly seeing here on campus, and maybe what are some of the issues with each, or things to maybe avoid, or things to look out for?
I'll start, and then others can join in. So the main recommendation is stay on campus as long as you can, and look for sources of non-dilutive funding. So whether it's research grants or other kinds of funding on campus that you can get from like an accelerator or something like that. Anything that doesn't require you to give up equity in your company to get it is probably your best bet, at least starting out. So I would recommend, and we always recommend, really make sure you're ready to launch a product into the market, i.e. you've got a lot of the things we're going to talk about later, but you've got product market fit, you've got customers lined up, you've got manufacturing and distribution in place and ready to go before you go out and seek funding. Just increase the likelihood of failure and having to do down rounds and such if you make a mistake on any of those pieces when you've raised funds before you've done those things.
Anyone maybe, can you expand on, I guess, a little bit and highlight what is qualified for such non-dilutive funding versus maybe what's not? The types of research you might be doing or the types of development. Where does the kind of fork appear in the road for when you may have to go outside campus to fund your work?
Well, you have to look around on campus and see what sources of money are available. There's a number of them. There's the WARF Accelerator program, which will help you develop your technology and experiments, which is what I consider technology de-risking. Then there's also competitions. Business plan competitions. There's also seed funds available. There's Draper TIF money available. There's SBIR funding that's all non-dilutive, so it won't require you to give up any equity to use that money. So be resourceful, but also come talk to us about where you are in your development life cycle, and we'll help you find what source of funding is right for you at that particular point in time. And we'll do that based on your technology's maturity, your readiness to go to market, those kinds of things. Because as you get closer to get to market, then you won't qualify anymore for some of those, free funds or non-dilutive funds, and that's when you're going to be looking for an equity investor if you need capital to raise to start.
Melissa, do you?
Sure, I'll jump in. So I think there's if anybody saw me cringe when Justin said friends and family around, like Ann and I'm sure have war stories. People come in and like, oh, don't worry, my friends and family, I've raised, 30 grand. So I think the first thing is the first money that you raise is going to be the most expensive. If you're selling equity, the company has minimal value, it's going to cost you substantially more equity up front, it should, than if you're, having success. So think of it in buckets and think of it from an investor's perspective of reducing risk. David said de-risking certain things. If you take $500,000, what are you going to do with that money? What risks are you going to reduce so that if you go raise a big round after that, you get a step up in valuation? So be thinking about that. You can take different equity rounds. You can take a bridge round up front. But if you're not going to have a follow-on, a bridge round is a debt financing piece. You're actually taking a loan from your investors, and they don't exactly know how much equity it's going to convert to because it's going to be dependent upon the next round of funding that you raise. So if you're not going to raise that next round of funding, a bridge round probably isn't right for you because you're building a bridge to the middle of nowhere, right? But there's different, and it sort of depends on, like they were saying, how much you want to raise, what you want to do with the money, how long it's going to last you. My big rule is it's always going to take longer and cost more. So if you think you need 500, go out and raise 6. If you think it's going to last you 12 months, how much do you need to get to that 18-month mark? And depending on kind of where you're at and what the answer to all of those questions are, leads us down, should you go raise Series Seed? Should you raise a full-blown Series A round? And, you try and do it in steps. So if there's pieces that you can bite off for less money, do that. And then, you get an elevation in valuation, you can go raise more money at a higher valuation. That's how you keep the most equity as a founder up front.
Do you have any rules of thumb, anyone on the panel, for in terms of who you should be targeting for those monies? So we talked about a Series Seed versus maybe an A round or a B round of funding. Are there, dollar amounts that you would think about for each of those? Is it more of kind of milestone based? Anyone have any comments on that?
It's dollars for the most part. Series Seed to me is probably anywhere up until maybe 750,000, and even higher than that. I mean, a true when people say Series A round, they probably mean multiples millions of dollars, $2 million, $3 million, $4 million. The other thing in terms of this is one of the other things that we see companies make big mistakes at. There is a concept called an accredited investor, and it is a designation made by the SEC. And for the most part, it essentially means high net worth, wealthy individuals. There's a couple of different boxes that you can check. If you are selling equity, if you're selling securities, and a debt instrument, if you're selling a bridge round, convertible notes are still considered securities, so you still need to comply with these rules. You are selling securities to people that are unaccredited, so the people that do not meet those definitions. There are a whole host of other hoops that you need to jump through because the SEC is concerned that you're going to fleece grandma out of her remaining $30,000. Right, grandma, this is a great deal. Put in your remaining 30 grand today, and I'll give you 130 grand next week. That's what they're concerned about. And so to actually do a proper funding round to unaccredited investors, each state has something called blue sky laws. The only thing you need to know is that each state has different rules and regulations, and it captures the number of people that you can make offers to. Notice how I didn't say make sales to. So even just the people that you are going to go to and make an offer to sell your securities. It usually picks up a 12-month window. Some states are Wisconsin is very state specific. They only care about the number of unaccredited investors in Wisconsin. California, typical California, they're different. They look at all states across the board. But you need to put, again, if you're selling to unaccrediteds, they should be getting 4 or 5 pages of risk factors telling them in 4 different languages and 30 different ways how they're going to lose their money potentially on their investment. The issue is if you do not give proper disclosures to unaccredited investors and they lose their money, they can come back after the company, and you could be in securities issues. You could have securities issues where they could rescind their investment. You could have to pay it back. There's penalties. So a lot of times people come in and they say, I just need 50 grand. My cousins and uncles are going to give it to me, but it's actually probably going to cost you a third to a half, a third or a half more to sell to those unaccredited investors, because there is more documentation that needs to be done to make sure they understand exactly what they're getting. So I understand that sometimes you have to deal with those investors and you can't take money just from accrediteds, but if you can limit the people that you're even offering your sales to accredited investors, it just sort of raises you up a level. And you also, I think personally, as an entrepreneur, if you're taking somebody's money, these things are going to fail. I would really hope that if they fail, you're taking it from somebody who can afford to lose, that 50 grand versus grandma who is out on the street now. So that's a really big concern when people, that's why I say when people can't come and say friends and family, attorneys cringe, because it means something different. But I think in terms of amounts, like I said, probably 750 up to $1 million puts you in the seed round. You can raise $1 million's about the top that you can raise in a debt financing round. And Series A, Series B, those are kind of the big rounds that you think where you're going out to raise millions of dollars.
So I have a technical question.
Okay.
Go to your friends and your family. Do they need to be accredited in order to take their $25,000?
They do not need to be accredited. They can be unaccredited. But if they are unaccredited, that's where the additional risk factors come in. You then need to be running searches for blue sky laws in each of the states where those investors live to make sure that you're within those. And that goes to anytime you raise equity, you need to file what's called a Form D. And it's a securities filing that says, here's how much we've raised, and here's the exemption from being a public company that we're relying on. And that document gets filed with the SEC. A copy of it also gets filed with every state where an investor that you're selling to resides. So that's where the blue sky laws get tied in. If you are making offers to people in Connecticut and California and Texas and Missouri, they're all going to have different statutes that you need to rely on and different filings in those states. But more importantly is the risk factor piece and really doctoring what they're signing so that you have that full-blown, yes, they knew what they were getting into. They knew it was risky. They knew, we told them in 30 different ways how they could lose their money, and they went into this wide open. That's what the SEC is concerned about. If you're selling to accredited, they sort of leave the accrediteds alone. They just say, you're sophisticated business people, you've done this before, you're wealthy, we're not gonna second guess your decision to invest.
It's also uncomfortable to ask your relatives and friends if they're accredited investors, so think about that too.
Yeah, that's right.
Yeah.
That's right.
But I would say, so that's an interesting point. That usually is a representation that an investor will make in the investment document. They will literally, there's a number of representations that they give, and one of them is usually, yes, I'm accredited. There's also a questionnaire that you can send, and they can just check the box that they match. And at that point, the company has done their diligence. You do not have to request bank statements. You do not have to, dig into their personal life to figure out whether they're lying or not. To do those types of offerings, as long as they say, yes, I'm accredited, you're done. The reason that's important is because crowdfunding flipped that switch. And there are certain types of crowdfunding that when they first came out, everybody got all excited about, but it actually put the company, it switched the obligation, and the company now does have to dig in and say, give me your financial statements. I need to personally verify that you are accredited. And you can understand, to Ann's point, how uncomfortable that is to go to an investor and say, just send me your bank statements when you get a minute. Great.
Yeah. Be quick with those, I'm sure. All right, well, so we've talked now about raising money and getting money in exchange for equity. So let's talk a little bit about how you go about distributing equity at the outset, setting up your initial cap table, reserving some equity stock options. Anyone on the panel? I'll just open it up. Anyone have any initial thoughts on how much time should be spent thinking about this at the outset? Who should get what for maybe past contributions versus future contributions? Panelists, your thoughts?
I'm not going to give best practices, but I will say that this is one of the major fail points of any nascent company is this equity discussion, and this is where we tend to see a lot of clashes in personalities, clashes in understanding, and really a very sticky point for this. So getting on the same page relative to this equity distribution, especially if you've got some deal in the works, if you've got a customer who's ready to sign up and buy from you, or you've got a strategic partner lined up, these equity discussions can derail you significantly. So if you're anywhere near that, you've got to have these conversations, and they're not a whole lot of fun. So I'll leave it at that.
Michael, yeah, any thoughts?
I guess what I would have to say, from all of the points that they've made, is that the agreements that you're going to look through are really, really important. And we all have all of the things where we just click the box and say, oh yeah, sure, that's fine. The fine print, nothing bad is going to be in that agreement. You need to read all of the fine print, and you need to set out all of the bad things that can happen, and also all of the good things. What happens if all of a sudden in a year or 18 months, Google wants to buy you for $1.8 billion when, YouTube. People change when real money is on the line. I can tell you that from personal experience. They change, and if you haven't written it down, you're going to be on your own.
Yeah, thanks for that.
So a couple of common things that we see that I would say are big mistakes. People always want to go 50-50. I have a partner, we're equal in this, and you then have to find a pretty reliable tiebreaker source, because if you don't agree on something, you're deadlocked. We saw an interesting one time, the original version of Candyland. Whoever won the best 2 out of 3 was the tiebreaker. So if you're determined that you're in it with one other partner and you're going to do 50-50, you can't agree on any other split, then you have to come up with a tiebreaker that's going to work for you. And the other one that we see is there may be a group of people who have been working on a idea for quite a while, and they've made significant progress, but they need another, they need the business person, or they need another developer, and suddenly they want to throw 30% equity at them and not put a vesting schedule in place. And you don't even know that person. And I always tell people that going into business with people is in a lot of respects like getting married. It's a really major relationship in your life, and you have to be able to trust those people. And you shouldn't you wouldn't get married. Very few people get married after the first date, so you shouldn't throw all this equity at someone right after you meet them.
That's a great segue, because I did want to ask one quick question on this, and that is, on this note, is it better to give equity? You mentioned, we need this person to do this, perhaps this software development. Should I give them equity or should I pay them? And are there any factors to kind of consider in that decision?
That's a tough call, because generally you don't have the money to pay,
right.
So you pay with equity. And sometimes we see people that have a cap table that is so full of people that were with them for a couple months because they hired them to do something, and then they left and they gave them the shares and they didn't vest them, they just gave them to them. So
vesting is a key theme that we keep hearing. Yeah.
The balancing act. You really, if you can scrape together some money to pay somebody at least for a while, that's a great thing. So you can test whether they really deliver on what they promise. You have to be very careful.
And I think one of the things that we see when companies just get started, the founders just think of equity as free money, and they don't actually give value to it. And the answer is, in 6 months or a year, if you're doing your job, that's really valuable. And so giving somebody 20% or 30%, is a ton of value. And that's one of the big things, Your equity, yes, that maybe there's no assets in the company and it's day 2 of getting the company off the ground, but that is valuable and that is worth something. And so there is this balancing act. So I think we've obviously talked about vesting a lot. The other thing is an option pool and putting in place an option pool. And the reason that that's important is because when you start making hires, like these people that we're talking about, you want to be taking their shares out of the option pool, giving them to them with a vesting schedule. And the reason that that's key is because if you don't take it out of the option pool, you can't put it back in. And so we had a scenario which just kind of creates some gymnastics, but if a founder leaves, the shares are going to get clawed back if there's a vesting schedule. But if they're not coming from the option pool and they don't go back into the option pool, everybody's ownership goes up slightly because now there's less shares in the overall pot, right? And so anytime you're dealing with advisors or consultants or employees, you want to make sure that the shares you're giving them are coming from this option pool, because 1% then doesn't change. If you're giving 3 people 1%, they're getting the same number of shares. Whereas if you're kind of pulling them from this phantom place and then they're not going anywhere, the company's just sort of retiring them, that number changes. And you could be giving people 1% on day 1 and day 20, and they're getting a different number of shares. So there's a lot that goes into this. I hate to say talk to your attorney, but talk to your attorney. We can at least give you ranges. Like if you're going to go, I need to go hire my co-founding tech guy. Great. I'll tell you between blank and blank of percentage of the company that you should be at least talking about, right? I need to go hire an advisory board member. Great. Let me tell you what, and advisory board members are different than employees. Their vesting schedule is different. Their agreements are slightly different. So unfortunately, one size does not fit all. The other thing I would say is stock option grants are one of the key diligence items that your investors will literally dig into. And we have companies that, when I work with my companies, I say, for the most part, taking out stock options, here are these form agreements that we've helped you with, customer contracts, whatever it is. And if you're comfortable negotiating various changes to them, I don't need to be involved. Use me as you see fit. I don't need to oversee every aspect of your business. I would never get anything done in my own life, right? But stock options are one thing that, unfortunately, the companies lawyers need to be involved in. There are tax consequences to it. The board has to approve every single grant. The exercise price has to be set as of the date of that grant. There are vesting schedules that get updated. There are various pieces of different documents that have to match up. And when a new investor comes in, they will tie out every single part of your cap table to every single contract that you have. And a lot of times, if you've been doing it on your own and then your attorney gets involved, that's where the fees start to rack up, because there's a lot of cleanup that has to be done. And a lot of times the board is fine with it, right? But you look kind of silly going to your board and saying, here are 8 things that we need to ratify. Well, why did you do? Well, because we didn't properly approve them the first time. There are just certain things being kind of a real company means, and keeping that stuff in a good form is something that you have to do. There's a great tech company, I'm sure people are familiar with it, called eShares. They're now Carta. We have a number of clients on it. It won't let you go outside of the lines, basically. Like if you don't have enough shares authorized, it doesn't let you make those grants. So it's kind of another check and balance, and it's a lot easier then for an investor to come in and do the diligence because everything is on Carta. And the other thing is they do these great 409A valuations for free, and those are usually between $5,000, $7,500. It's really coming in to value a share of common stock for the company. You'll have to do that after every financing round that you do, and they do them for free. And I don't get a commission from Carta. Maybe I should.
So another comment I'll make about this whole equity sharing discussion is, and this happens here at the university in particular because of the principal investigator, graduate student, postdoc relationships that evolve. That's another area of potential stickiness here at the UW is how do you distribute equity at the point where a company is started from something that's been in a PI's research area that a grad student has worked on, that other people have contributed to, maybe other universities have contributed to. So, it's difficult to navigate those conversations. I don't have a one-size-fits-all, but just be aware that those are very touchy points when you're forming your company. And what I would suggest to do, if you're the one who's actually taking the company out, is try to view equity as the work that's being done from the point that you start the company to the point that you start to collect revenue to the point that you start to gain profitability and beyond, instead of a backwards look at how did you get here. And that might cause difficult conversations, but you have to remember too that if you're starting with no money, your equity is your money, and so you have to spend it wisely, right? And you can't be just giving away your money for everything that's happened in the past and not have any money to go realize to get your product into market, to build a channel distribution, to sell, to compensate a sales staff. So you really need that money equity in order to do the things that you need to do in order to get that company to be successful. So if you've given it all away, you've really limited your resources, and that's not going to help you actually get any value from that equity anyway. Another way to look at it.
And along that same line, if you are a postdoc or a PhD student working in a PI's lab and you're the one that wants to drive the company forward, and the PI often thinks that, and they don't really want to have a role in it, but it was their idea or it happened in their lab. Those are really difficult conversations to have about how you think the PI shouldn't get a very big percentage because you're looking forward as to what needs to be done to actually turn this into a business, not looking back on what great science was done, as David was saying. So having a thoughtful plan on how you want to have that discussion is essential, because it's a difficult discussion to have.
Yeah, and maybe one of the things that feeds into that difficult discussion is a business plan and thinking forward as to what this technology is going to be, how it's going to be embodied in a product. So we'll turn to Michael here and discuss, is a business plan necessary? I think this is one of those things that we kind of hear maybe dying, but yes. Yeah, is this on? Right.
Yes.
Yeah, so Michael, maybe you could step us through it. Is a business plan necessary? And, what are some of these different names we're hearing for things that are related to business plans now?
Yes, they're necessary. I teach entrepreneurship. I'm not just trying to say that because I want you to come to my class and create business plans. And what does it do for you? It gives you time to analyze whether or not your business model will work. So it gives you a little bit of time. A lot of times entrepreneurs are really busy on developing the product, trying to figure out what might sell, and they don't take the time to look at that side to see if there is this product market fit. Do you want to
Sure,
add?
I'll add.
Yeah.
So a business plan is really the end result of all the work that you need to do to validate that you have a market that you're going to sell to, that you've got a product that fits in that marketplace, that you've got a strategy for how you're going to launch that product into the marketplace, that you've got you have something that's going to be differentiated enough that your potential customers will want to buy that versus other solutions that are in the marketplace. So the business plan is really the end result of all of that work. And an accelerator, will help you figure out what needs to be in there. But if you want to raise money, you need a business plan. If you want to start your company, you should have a business plan. You can certainly wing it. You can start your company. You can bootstrap, and you can go out and build something, and you can try to start selling it. You don't have to have a business plan for that. But if you want to an investor to come on board and help you on get your product to market or hire sales staff, you're going to need a business plan. Not only that, but it forces you to make decisions about, you've got limited time, you've got limited resources. So what are you going to spend your time doing? What's the most important thing that you need to put into your product on day one in order to get a sale? What's of the 5 different options for how you could market something? What's the priority order of the things that you're going to do to try to sell your product? Like what are the most important channels? What's the most important message that you need to tell? So creating your business plan forces you to think through the options and make smart decisions with limited resources about which of those options are the best thing for you to go do. At a high level, what's included in the business plan? So who's the customer, right? what's the problem? What's the specific problem that you're solving for that customer? And what's the value to that customer of having that problem be solved? So if you can't answer what does it mean in terms of real value to that customer, you're going to have a hard time convincing somebody to pay you money for it. They might think it's a great idea, and they may think, wow, that's a really awesome innovation. But if they can't translate that into, okay, if I spend $100 on this, I'm going to realize 50 hours of savings, or I'm going to gain 10 more customers, right? If you can't translate it into their terms of business benefit, you're going to have a hard time selling it to them. So who's the customer? What's the problem that you're solving? What's the value to them of solving that problem? Then specifically, what is your product or service that you're delivering to them? You know, define it. What's in the box? What all comes in the package? What has to come in the package in order for them to be able to use it and adopt it? What's your development strategy and your roadmap? So you're not going to be able to do everything that you envision doing on day one with your product. So you have to think roadmap. What's your minimum product that you need, that you have to have in order to make a sale on day one? And then what things do you add in over time that either enhance your customer satisfaction or open new markets for you, right? New customer segments. The market size, market description in the most accurate and precise and smallest terms possible, most accurate terms possible about your market and who you're approaching, what your team is composed of, and more importantly, what value do your team members bring to the table that you can leverage in your business? Do they have something specific about the market that you're going into that makes them a credible person in that industry? Do they have a particular expertise in technology that no one else has that's going to set you ahead, right? What is it about that person, not just their name and their background, but what is it that they bring to the table that's unique and will help you be successful? Competition. So you can't get a business plan approved without a good discussion around who the competition is. And when you're looking at that, don't just think other products that are in the market that you're way better than, but think about the problem that you're solving and what are people doing today to solve that problem. Because it might not be that there's a one-to-one competitor for you, but they're doing it today somehow. So what is it that you're doing markedly different from anything that they can put together today?
Can I interject one piece on that?
Yeah.
I used to judge the governor's business plan competition, and I cannot tell you how many times people would get to the competition section and they literally would say none. There is not a single business that you can start that does not have competition, even if that competition is getting somebody off their couch to do something other than watch TV. So David makes a great point. Like, think of it outside of the box. There probably is not a one-to-one comparison, but that does not mean that you have no competition.
Yeah, thank you. That's a very good point.
In all of the plans that I've read, evaluated, some as an investor, many as an instructor, and it's been thousands, this is the section that people leave.
I would just throw it in the air.
Yeah.
Like, no.
We're so good we don't have any competition, right?
Right.
Yeah. Force yourself to come up with at least 3 competitive solutions to what you're doing. May not be companies, but it could be something that people do by themselves within a company. And then funding required. So what is your development roadmap going to cost? What is your go-to-market plan cost? Customer acquisition, to use a fancy today term, right? And then what are the milestones that you expect to achieve? So those are the nuts and bolts. That's basically what has to be in your business plan. And again, it's a process you go through of evaluating your different options for each of those sections and putting together the best combination that reduces the most risk and increases the chance that you're going to be successful with your business. That equals your business plan.
That's a great description of the flow of the plan, problem, solution, and going through it. But what are people looking for as investors when evaluating business plan? One is large market opportunity. Is this a fast-growing market? If not, you'll probably get off to the side. Do you have a competitive edge? And that doesn't always mean patents. Okay, are you doing something especially different than your competitors that sets you apart? And then the last that I would put, these are my top 3, is the team. Do you have someone on there that's sales oriented? Somebody who's actually sold something, okay? And then do you have experience within this field and being successful? And a good technical founder, obviously, if you're doing something technical. But the whole plan needs to explain your business model. It needs to be consistent throughout. And I put a note here when I was making some notes. Financials, do you need financials in there? Yes, you do. You need financials in there. But most people, when they evaluate them, they're going to look for mistakes. That's what they look for, are the mistakes that happen. Either because the numbers aren't adding up, or there is some type of claim that you make at the beginning of the business plan that then isn't reflected in the financials. Expenses are controllable, so they're not going to look at those, right? They're going to look at your revenue assumptions and whether or not they're credible and if you've made some type of mistake.
Yeah, and if you think about what an investor is doing, right, they're taking their money and they're trying to put it into opportunities that are going to return money back to them. And they have a lot of different opportunities to choose from. So they're looking to minimize the amount of risk that they take on for the return that they expect, right? So they're going to be crawling through your business plan and looking for holes and looking for things that don't make sense or things that are asserted but not backed up with any kind of testing or in-market expertise. So it's really about the business plan. The way I look at it is, it has to have all those elements in there because it says you thought through them, but also you've got to be an expert in each of these, right? You should be the credible expert in each of those categories, so that if I ask you something about competition, that you don't say something like, I don't have any competition, but you say, okay, well, here's the competition as we see it. Here's where we differentiate and why we're delivering so much more value to customers than the competitors are able to today, and why they can't duplicate what it is that we're going to deliver into the market because they don't have XYZ expertise, they don't have whatever is on the team. So you can see that it's more than just, did I fill in the boxes, but it's investors are looking for a level of expertise and risk reduction in order for them to make a decision about investing in your company.
Well, that's great. Yeah, and now as we think about, obviously, a business plan as needed, talking to different audiences, be it investors, be it trying to solicit new employees to work for your company, or maybe you're trying to obtain a license from WARF, describing your technology in a way that may be accessible to a wide variety of audiences, but also maybe you need to get into a technical discussion of your ideas. And so we get a lot of questions at WARF, and I know my colleagues on the panel do as well, about non-disclosure agreements. Are they needed? And depending on whom I'm talking to, what's protected. So Anne, maybe you want to touch on non-disclosure agreements.
So I'm going to touch on it by telling a story about a client that we had who had some high science, some biotech kind of, that was what their science was based on. And they were at a point where they were thinking about raising money and they wanted to talk to some investors. So we were going to introduce them to some people that we thought could really be helpful to them and help mentor them because their idea seemed like it was a really good one. And they came to us and said they wanted a non-disclosure agreement to present to those investors before they would talk to them. And we advised them that that was a bad idea because people that are volunteering their time to talk to people with ideas and give them their best effort are not going to want to be bogged down by worrying about violating non-disclosure agreements, and they're people that their reputation is their gold, their currency, so they're not going to go share your idea with everybody else on the street corner. And they insisted that we give them an NDA. They went to that meeting, and the two investors said, we're out. If you make us sign this, we're out, because we just don't do that. So you don't want to take an NDA to an extreme and limit your opportunities. They play an important role in certain situations, but you can use them in a way that is to your detriment.
One of the things that I meant to say during the business plan part is I get a question: should I put everything about our business in there? And you want to keep your secret sauce your secret sauce, and that goes to investor meetings also. They can see the secret sauce when they write a check. That's how I tell my students, and that seems to work. Keep that. If you don't have a secret sauce, yeah, maybe think about looking at something else to do.
I mean, NDAs come into play not just from an investor's point of view, but also in collaborations and in strategic partnerships, co-development efforts. Basically, if you're having a technologist to technologist conversation and you don't want them to, essentially grab onto your idea and take it. And so I'll share my thoughts on that, and I'm not an attorney, so please consult with your attorney.
Yeah.
Borrow my attorney hat.
I think NDAs are difficult for a couple of reasons. One being they're very difficult to monitor and police. So just because you have somebody that signed a confidentiality agreement with you or a non-disclosure doesn't mean that you're going to know everything that they say in a backroom conversation with somebody. So you can't, it's very difficult for you to manage them. Secondly, it's also very expensive if you want to litigate that, right? So, it's going to cost you a lot if you're a startup company, right? And you have somebody like a big animal that you sign a non-disclosure with, and it turns out that a year down the road they have a product that looks just like what you were talking about. Good luck suing them, right? Because it's going to take deep pockets for you to be able to go back to that NDA and through a lengthy, expensive discovery process, find out exactly where they did or did not, disclose confidential information for you. So be careful with non-disclosures. I don't feel like they do a lot of good, but there are situations where you definitely need them. I just think, from a practical business perspective, it's hard to spend the money to get anything of value out of a non-disclosure, right? They protect you, but then at the same, it's more of a, an agreement type of like a handshake agreement, I think, because are you really going to pursue suing, a potential partner because you think they violated confidentiality? Maybe, but it's going to be very, very expensive for you to do that. So there's just, if you're a startup company, I think it's particularly difficult for you to show an NDA to a potential partner and have them just sign off on it. Most times their legal is going to be the ones that come up with the language that's in the NDA, and it's going to be favorable to their side, not yours. And you're unlikely to get anything changed if you don't agree with some of the terms. So yeah, I'll just stop there. But I can go on and on about NDAs.
I think there is a place for NDAs, and I think that is in large part in the startup world where you're working with other startups or you're working with certain people that you need to move your business forward. And the good news is, David's absolutely right. It's expensive to enforce them, and it's difficult to figure out what was what and what you came up with on your own and all those things. But for the most part, people are pretty honest, and when they sign something like that, they realize they've made a commitment to you not to disclose your information, and they'll do their best to do that. And that's, when you're using them, that's really what you want.
Mm-hmm.
I think it's definitely worth it to put it in place. It's just good business practice to do it. I also think the question, kind of to David's point, really gets down to, from a business perspective, who has the negotiating leverage, and are you the party that has it or the party that doesn't? The other thing is that there can be some kind of tricky language in NDAs. So the first thing is, if you're working with another company, and if they're sending you their NDA, is it mutual or is it one way? Right? Because if it's a mutual agreement, they're agreeing to the same things that they're trying to get you signed up for. So that gives you a little bit more comfort. Like, if we're agreeing to do this, we can ask you to do the same thing. The big sort of sticking points that I would be careful about, one is, how is confidential information defined? That, again, only attorneys can argue about, like, defined, terms, but sometimes it specifically says that it has to be marked confidential, or if it's oral within 24 hours, you have to specifically say it's confidential information. That's a little bit, more narrow than we would like to see. I mean, who knows? If this is going to be a long-term relationship, you can't you can't agree that only everything you mark as confidential is going to receive that treatment. So that's one thing to watch out for. The other thing to watch out for is what pulls something out of the definition of confidential information. And a lot of times that's stuff like, is it available in the public domain? Did the receiving party get it from a third party who doesn't have any obligation of confidentiality? The one thing that I've started to see a little bit more often, which is very concerning, is essentially a statement that if after you're done working with them, if it's the other side's employees and they remember it in their mind without referencing back to any notes or things like that, that it doesn't receive that treatment. Stuff like that is where you kind of start to, like, who am I dealing with on the other side? Because that really feels like a gotcha, right? And that I would expect that to be in a one-way where they're saying, tell us all of your information. And by the way, if we just happen to remember it without use of notes, how are you going to prove that, right? Can you imagine trying to argue that provision? Well, of course they looked at their notes. So, there's a lot of times people just think NDAs are really standard and I'm going to Google one and pull it off the internet. And for a lot of times that's right. But you really need to, if you're not going to hire somebody to look at over for you, literally read every single word in that agreement to make sure, there's no gotchas in there, because we do see those.
Thank you all. So we've got a couple more questions, but we've only got a couple more minutes. So we're going to blend these last two together on what you can expect from Accelerator, as well as where do I go from here? Because they do kind of go hand in hand. So I'm just going to hand it to the panelists to each spend about 30 seconds to a minute, kind of giving, where do you go from here? And we'll open it up for questions.
So accelerators can be good for the right people, but they're not the answer for everyone.
Great.
I would agree.
I think the most important job of an accelerator is to help you validate your product market fit. It's not so much about your business plan, because if you've made a mistake on product market fit, you can write a business plan, but you're going to be going back to product market fit before you have a business plan that's going to be able to attract investment. So I think that the number one job in an accelerator is to help you, right? To help you wherever you are in this process, whether you're at the idea phase or technology proof of concept, or if you're at market de-risking, or even if you're at launch. So it's to help through that whole process, but to force you to do the things that you need to do in order to validate your product market fit. That's kind of the number one job of the accelerator, at least from my point of view.
And I would just say, really consider the reason you're going to the accelerator. And if your top reason is for connections, you're probably not making the right decision. A lot of people don't think of service providers, accountants, attorneys, insurance providers. People that work in the startup world have a lot of connections. I sit in on board meetings for my clients. I'm connected to their investors. Anybody who actually works with startup companies has a lot of connections. And so accelerators are great. Their connections are a big piece of why people go to them, but don't discount other people that are in this industry, people on this panel. I mean, I'm sure that Anne and everybody is connected to a lot of people that you really wish you could get connected to. And so a lot of times people just think, I got to go to that accelerator to get their connections, look elsewhere.
Great. All right, so with that, why don't we open it up if there's any questions from the audience? We've got some microphones floating around here, so got one there and one there.
I tend to be pessimistic in general, so my question is this. What happens, or what type of bankruptcy strategy should one follow if the venture is not successful? I suppose a lot of that depends on the how you're incorporated, but what are other issues to consider, like what type of bankruptcy, whether it's Chapter 11 or 13 or 7 to pursue, and what are considerations in that area? Thanks.
I'm not a bankruptcy attorney, right? And a lot of times, if startups are going to fail, there's really not a lot of assets that you're fighting over anyways. The first question is there any type of debt outstanding, right? Just looking at the stack of owners, who are going to get the assets. If you have any money from like Wisconsin Economic Development Corp or Madison Development Corp, all of those debt instruments are going to be secured. And so if there's anything remaining, they're going to get it. Now, I think that gives you an interesting negotiating point, because I suspect if you're a technology company and your app is what you have, right, what is the WEDC going to do with your app? So in my context, a lot of times if companies are going to fail, they don't even go through the bankruptcy. They're just not big enough. There's no reason to do it. What they'll do usually is, give out whatever assets they have remaining, liquidate the company, and, on to the next. It's rare that we see startups go through any type of bankruptcy.
Thanks, Melissa. I think we have time for one more question.
Okay.
Yeah.
Yep, they do. And I will say, I found them to be, they're willing to negotiate. Like if there's a promissory note, that they're not going to be the ones that put the company finally under. They've been really flexible in terms of extending interest-only periods or things like that.
Yeah, Bob Rushline, Real Economy Institute. In my experience, losing control of a company can be really devastating. And so the distributing equity, what do you think of the idea of either Class B non-voting stock or a limited liability situation where you have a managing partner and then investor partners that don't have control over the company? What do you think of those two options to maintain control of a company? Because it's very easy to get outvoted. I mean, look at it even happened to Steve Jobs, things like that. So you want to maintain creative control.
So I would say that I work with, like I said, technology startups. And the answer is, even if they're selling 20% or 25% or 30% to an investor, they're giving up substantial control, because their investor is going to have what we call protective provisions, which are the material decisions of the company that they will say, you cannot make these decisions without potentially the investor's specific vote, and or putting somebody on the board who has, even if they have one of 3 or one of 5 seats, there are going to be various director protective provisions as well. So the board has to approve, and that specific director is going to have a veto power over. So the interesting thing to me, I think, when most people think of control, they think of ownership. And they think if I maintain 60% of the company, I maintain control. And that simply isn't true when you bring outside venture or angel investors into your realm. If you're going to sort of high net worth individuals that are just investing in you personally, I think the options you laid out absolutely work, because there are certain things that you can maintain control over. But once you go and you get sort of a venture type investor or an angel investor, you're going to give up substantial control, even if they don't control a majority of your company.
Well, thank you all for your attention and your questions. Please give the panel here a round of applause. And we look forward to continuing the conversation in the reception. Thanks again.